Hello, my name is Jay Chauhan, and in the Angel Mentorship Group, here is my topic for the day, which is communications for lawyers. Is in my view, the profession is based on our ability to communicate. And how do we communicate? We communicate by voice, by writing, by drafting pleadings, appearing in court, or even talking in different ways to different people, including family members. So I want to just give an outline of the issues we should think about when we communicate. So first of all, when we talk, it is important not to broadcast your message and convey what you want to say. It's important to remember that the message you convey is message to the group or a person anywhere in the legal arrangement or even a family is based on what the other person might hear the message to be. In different words, you have to create the words and expression that'll make the impression correctly in the mind of the person hearing the message. For the way we speak, and very often people speak their minds, but do not think of the people they're addressing the comment to. So my first comment is that wherever you're talking, it's important to recognize who is listening to the message and then talk accordingly. For example, if you're in a courtroom and you have a lot of documents, it is very, very important in my mind that you summarize a large number of facts in the manner in which the judge might hear the message. For example, I'm acting for the plaintiff. Our position in a few words is the following, and therefore my opponent is this lawyer, and here's the summary of the action. If you're in the context of any other communication, it's important to remember who you're talking to. And so if you're a lawyer and you're talking in the family, you don't need a lot of legal jargon. You need to simply talk in terms of the issues that are relevant to the family members, and you talk. And why do I think this ability is important is because in the law school or outside, we get very little training anywhere on how to communicate. So I think this talk is designed to make you sensitive and develop your skills around the ability to communicate properly and also more effectively when you talk to other people. Now, in more specific context, in our group, in the Angel Mentorship Group, in the Corona period, we have developed a number of ways in which we communicate. So I just want to summarize some of the methods by which we communicate in the Corona period. One of them is the WhatsApp system, which is become much more popular recently in Canada. And in that arrangement, you can either talk in terms of the voice, or you can have a picture, you can have a video, or you can simply send a message. So that enables a person to communicate instantly to another person. And just to give you my example, although we have a phone system in the home, I carried the phone around in my pocket so other members of the family are not disturbed, and you're still able to communicate in a short message what you want to say. And WhatsApp is designed specifically to make sure that you're communicating with very short messages. So that's one of the programs that is important to get to know in our group, and I would recommend that to any other law firm that wants to use effective systems of communication to carry out their legal work in the Corona period. The other one is the traditional use of the emails. Sometimes people use emails to send short messages similar to a messenger. My view is that if you are using the email system, the email system should be used to have a substantial message communicated. But you have the facility today of the cell phone being able to see the email, WhatsApp, and so many different types of media that the WhatsApp arrangement or the emails are not necessarily going to be used the same way in communication between different people. This is the suggestion that the email be used in a specific manner is also for the legal office, because when you are responsible for an office, in the traditional office, there used to be a phone system where the phone rang, a secretary picked up the phone, it gave the message to the lawyer dealt with it when there was a time frame, and then when the time came, you were able to respond to that message and able to deal with the message by telephone. But today we have a system where we have emails, and therefore when the email is being used with a lot of attachments, you might use it for the purpose of conveying a lot of information, like a whole motion, a whole pleading. It may come through the email, and that's a better way to deal with the email. So, Naman, I'm just doing a recording, and so this recording may be posted on the social media. So now the next method of communication is also become very popular during the Corona period is the Zoom meeting. Zoom program enables you free of charge to have a meeting of several people all at one time for about 40 minutes. But thereafter, if you wish to have a longer meeting, you have to make a subscription. And the helpful part of the Zoom meeting is that even the court system is currently using the Zoom program for the purpose of the meeting. Now, in a Zoom program, you can see the different people. One thing that I noticed is that the ability to communicate on the Zoom includes your ability to see the other person. And Zoom enables you to talk right across different time zones and different distances without any difficulty whatsoever. So it overcomes the limitation of the geographic area in which you function. So if you're in Toronto, for example, and you wanted to have a traditional meeting, you would have a meeting in the office, as we used to have at 5 o'clock to 6 o'clock. All the people in the office came together and we discussed various files. But now you can go across the time zones and meet different people on a Zoom meeting. And therefore, I would recommend that if you have a group of people that are working together, that you have periodic Zoom meetings. So having said that, I want to just talk about the ability to communicate to different members of a legal firm during Corona using a working memo in a file. It is not traditional, nor is it taught anywhere that you should have a working memo in a file. Why do I think it is important? Is because as lawyers, we have a large number of facts that we are using to deal with in a file. So we have to define our role in a retainer, but more important than a retainer for the lawyer to carry out his task is the definition of that job on the client file in a working memorandum, where you list not only the legal issues, but also the practical issues that you might have to deal with. You can have all the education of a lawyer, but if you do not know how to file a statement of claim in the court, which you've never done in your law school, you may not succeed. And there are many people and lawyers who actually fail to meet the deadlines because they're not aware of the fact that, practically speaking, the working memo not prepared to deal with that issue is not given enough time and attention to figure out many what is called non-legal issues to be dealt with in a working memorandum, which is important in my view. So the next topic I'd like to cover is the pleadings. In my view, pleadings and the way you draft the pleadings is fundamental in the way you express yourself to the opposing counsel as well as the court system. If you are in a courtroom environment and you issued a statement of claim or a defense and you drafted the pleadings, the language of the pleadings very often follows the language and the culture of the law in that society. So if you're a lawyer in different jurisdictions, it's important to recognize the cultural norm of that particular jurisdiction and draft your pleadings in accordance with the norm of that particular jurisdiction. To just give you one quick example, if you're in jurisdictions where the court hearing will not be held for many years, then you can say whatever you want in the pleading and nothing will happen. Whereas if you were in Ontario and you make a comment in a pleading which is relevant or irrelevant, then it will have an impact on the other lawyer, because the pleading can be used as a part of the tool to create a strategy to deal with the solution of the problem that you're dealing with in common law system. Because the common law system is based on adversarial proceedings in which two parties are expressing themselves in a legal format with a short summary of the facts and the law to explain to the other party what they really want from the other party, or even the judge if you disagree. Now, what is the carriage of the file? This carriage of the file system is not taught in the schools, but it's very important to understand that when you are dealing with the file, you have to take initiative to carry the file forward. So one of our mentees some years ago had developed an approach, which many lawyers do develop, is they launch their legal practices and then they decide to deal with the file in response to something that somebody has done. For example, a client has given a call and said, okay, what is happening in my file? Then you respond to that one. Or the opposing lawyer says something to you in a pleading or in a letter, and you respond to that one. The responding system, in my opinion, is not the best way to deal with the file. You must have the carriage of the file, which you create a strategy and say, okay, here is how we will anticipate the proceedings and deal with the client and the opposing party. And then you have the idea of what is the next step, what is the anticipated strategy, and how you will deal with it as the file progresses. So that is what I call the carriage. So you should have a checklist. Once you're busy as a lawyer, you may have many files, and you must know each file where it stands so that you can deal with it in a very, very proper way, so that you're not missed out any possibility in terms of what you should do at the right time in that particular file. The next topic is in the communication, there's also, you have to communicate effectively. You must also organize your working day. So the work, once you're busy as a lawyer, the work is unlimited in amount. You can create new clients. You can be busy with existing clients, doing more research and more effort. And therefore, to make sure that you work effectively, you must organize your working day properly, knowing how many hours you have to work and when should you start to unwind, to make sure that you figure out. Most lawyers do not develop necessarily the skill to have the rhythm of the day properly organized, so that they have the time frame in which they will be working, the time frame in which they are relaxing, and therefore the organization of the day is fundamental skill, which is not easily acquired. You might think it is easy that you just organize your day, you do something, you know what you're doing, but it's not that simple in my view. So learn to organize your day, and I would recommend that in our group, actually, we'll learn this as an exercise, and it's important to have that particular exercise to be followed. Now, speaking. When you speak, many of us speak second, three, four languages. Very important that the language is cultural in nature. So when you speak in a particular language, for example, English is a language in which many ideas, like computer ideas, have been expressed and so on. So you should be aware of the language, and the precision of the language and ability to say something more precisely is very fundamental. And that ability is fundamental for the lawyer. But this is skill that is not taught in the school. You can pass a whole bar examination, a whole NCA examination, LLB, LLM, but you might not learn to speak properly to the other people. So I think another topic I want to cover and then end this talk is the question of submissions and opening statements in courts. This is also not taught in the schools, but it's very fundamental actually, that when you go to the courtroom, you have to keep in mind that the judge may not have the full grasp of the matter the way you have it, because you dealt with the matter much longer. So it is very important to rehearse. So moot courts are very commonly used in the law school for the purpose of training people, but it's entirely voluntary. So there are usually no specific subjects, but I think in our group, we want everyone to learn how to prepare your submission, rehearse it, because rehearsal helps you to gather your thoughts, gain your confidence, and repetition helps to make sure that when the time comes that you made your submissions very properly and thoroughly to the court, which can make the most most fundamental difference in the judge's mind, and you can get your way by making sure that you summarize your position and your perspective of the problem properly to the judge. So that ends my talk today on communications as a skill for lawyers. And I think Simraj is working with me right now and listening, and Naman is there as well. And I'll invite any questions that both of you may have.
Sure. This is Simraj Sandhu, the articling student at the law offices of Jay Chauhan. This question is framed around more so for articling students or young lawyers, but it could be working for older lawyers or lawyers who have experience as well. But what suggestions would you give for someone who wants to sharpen their client's communication skills?
So sorry, can you say it again?
Yeah, what kind of tips would you give for someone who wants to sharpen their client communication skills?
Sharp, what does that mean?
Sharpen to...
Sharpen the skill. Okay, how do you sharpen the skill? I think a lot of the skills of speaking, writing are a matter of practice. So I think that there are usually in the NCA or LLB no classes conducted to teach actually that how would you express. A lot of private schools in which you can actually learn. There are schools where you can go and private organizations where you can learn the public speaking. The speaking in human beings, amazingly, Simraj, is a skill that causes a lot of tension to a lot of people. And I think some people will have difficulty, including me, for example. I have, when I started my learning, and I went to several universities, and most universities, I never spoke in the classroom. And I think so the first important thing, Simraj, is that how do you open the door to learning to communicate is that sessions like this one, actually, where we're going through right now, are opening your mind to the idea of communication, then rehearsing it both in writing and verbally, and then asking for the comments until you perfect the skill and make it more effective.
Perfect. Secondly, so we were discussing communications through emails. This does happen to some people sometimes, and it'd be great to hear what your advice would be. Say you're communicating to a client and you accidentally sent an email to another client. What would your advice be in regards to that?
Well, I think most lawyers have a disclaimer written at the bottom of the letter that if it is sent wrongly, then to discard the email or destroy it or remove it, actually. And I think that a mistake can easily happen in the modern days. You see, in my days, when we wrote the letter, we checked it, the secretary checked it, and you signed it and put it in an envelope and put it in the mail, and it was a lot of ceremony around sending an email. Today, a click of a button can send out the email. And if you made a mistake, then it can be fatal, extremely serious, actually, because we're supposed to maintain lawyer-client relationship in confidentiality, which can be very important for us to make sure that our communication with the client is never revealed to the other side. So should you make that mistake, one thing that I learned, actually, which I would recommend to everybody, Simraj, which is that you never make a comment blatantly or bluntly, which is inappropriate. Talking about people, for example, writing even in your pleadings, naming people, writing in emails a message that how do you feel about somebody as a person, how ethical or unethical people are. So even if it's your lawyer-client relationship and sent to the wrong person, it should be drafted in such a way that you do not have to be over concerned about privacy. So my arrangement for every email I draft, I reread it. I ask other people like you to help me to make sure that is properly done. And should you make a mistake, you should be in a position to say to the person that was not intended for you, and please destroy the email, and that you're not left behind any damage to anybody, including your client, in the way you express yourself. So you should be very modest all the time to make sure that you express yourself correctly, but in a measured way in which it is not going to be offensive to anybody.
Great, thank you for that. Lastly, we've done this in our firm, so maybe we could talk about it and help other firms maybe. Just the way that we run moot court trials in our firm and how we've discussed like how we would prepare for a trial and how we would rehearse it. Maybe you could tell other firms how to run it smoothly.
how to prepare for a trial. Or you,
Correct.
yeah, I think that there is a whole trial record, and also the whole preparation. Actually, there's a pre-trial hearing actually in Ontario where you actually the judge watches and sees that all your factum, all your arguments, all your book of authorities are properly prepared and ready. Then I think what my system was that I followed other experienced lawyers was you create a binder. In the binder is for the purpose of examination, cross-examination of witnesses and your opening statement. So you go through the binder and there is a podium in which you can actually put the binder on your on the desk there, and then you can watch it as you go. So you have made your opening statement and you know the key points that you want to make. And for example, today when I talk about communications, I had this particular checklist, which I'll send it to you and anybody in our group so they know how to communicate. So I had all the issues rehearsed in my mind before I spoke today. And similarly, when you are in the preparing for a trial, you should have all the issues thought out, create a checklist, and in the case of examination in chief, you should have the question marks to ensure that the evidence of your client is presented correctly by the right question asked in the manner in which you prepare the client to present the answer. Now, the cross-examination is a little bit more tricky. How do you prepare for the cross-examination? I think I'm going to do it in one file with another member of our group where we'll be rehearsing this cross-examination system. The important thing to remember in cross-examination is that you want to elicit the facts which the other person is reluctant to admit because it is prejudicial to them. And by simply asking the question, it's important to remember that you do not have to badger the witness to extract the information you want. The fact that you calmly, in a composed way, ask the question is a statement to the judge that this issue is important to you. You have made your client make a statement to what you want to say in your evidence, but by cross-examination, you ask the question and wait for the other person to answer. So one way that we will rehearse that as a practice, actually, it's also not taught in the school. It's very important to learn that cross-examination is a little bit of a practice, but also it can be improved a great deal by being able to think on the spot on your feet to understand that if a person responded as a witness in a certain way, that you have the ability to respond back with a question that will elicit the person's views on that particular subject, which may be sensitive to the opponent, but you want to get it across. So I think that the cross-examination should be prepared. And then, of course, the binder enables you to know in anticipation who the witnesses are, both on your side and the opposite side. And you would have a binder opening page after page, the ring binder, that tells you what questions you're going to ask. So you're not forgotten to ask any question that you want. And then I think that you should have the opening speech to the judge and the closing speech prepared. So subject to what you heard in the trial, you will also bring in the conclusion in the end of your submissions, all the issues of evidence that were brought before the court, and then bring it across to the judge so the judge rethinks and consolidates his thinking based on what you say to him. And that's a good way to prepare, Simraj.
Perfect. That's all for me with the questions. Thank you so much for the answers.
Thank you, Naman. So I think if Naman has any question, I will answer the question. And if not, we'll conclude the recorded portion of the recording. Do you have any question, Naman?
No, Mr. G.
So it was good that we had this meeting. I would ask Simraj to upload it in the social media. And it was a pleasure to give a short talk on the subject of communications in the program today.